This is FN 2009-091200 in the matter of Lynn Mullen and Donald Lee Mullen. Counsel, would you please announce?
Yes, good morning, Your Honor. R.T. Bob on behalf of the petitioner, Lynn Mullen, who is present seated to my left.
Thank you. And sir, what's your name?
Donald Lee Mullen, sir.
Thank you. Let me ask both parties to please stand up and raise their right hands.
You need to be to solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. This is a return hearing. As the order says, I'm not hearing any evidence today, but under our rules, anything that you might say as litigants must be under oath, so that's why you're sworn. You're not going to be testifying today. The purpose of this hearing is basically to get the parties in court and to see where we should go from here. I guess I should ask, have the parties reached any resolution yet?
No, Your Honor, we briefly talked just before this hearing, and we haven't reached any resolution.
All right. Do the parties think there's any chance of resolution, or is it going to have to be a trial?
I think we have to proceed to trial. Our position is that he was ordered to pay these things. Mr. Mullen's position is that he doesn't have the money to pay for it. So we do have a fundamental disagreement there, and the amount in the petition I had, it was just over $11,000, and including expenses through today, I have it at $13,275. So because this is medically related expenses, my client's just in a very dire situation. I mean, she can't even afford to fix her glasses. She has to break her apartment lease now because she can't afford the place she's living in. She's charging all of these things on credit cards, and it has a high interest rate that accompanies that as well.
Sir, what's your position here?
Sir, there's absolutely no question that I do owe her some money. I think there is a question about how much money and the reason why. And again, I understand I'm not supposed to be presenting any testimony.
No, and I'm just kind of asking what your general position is. That's all.
I do believe that there's no question I owe her some money. I would like to settle this and get it done. I don't have any way to settle it at this point in time. But I would like help in getting a real number and a real resolution so we can keep this from happening in the future.
Ms. Baga, what's the dispute about the amount? I mean, I'm just wondering why you just can't get a judgment and execute on that. I mean, I guess it sounds like we're at a hearing. What I'm going to do is enter a judgment, and then I may or may not enter attorney's fees. And I just don't know if it's all worth the hassle if you can agree on a number. What's the problem with that?
Yes, Your Honor. Well, and I do want to also mention that actually per the terms of the decree, it actually states that if Ms. Mullen has to seek enforcement of the decree, that her attorney's fees shall be paid by Mr. Mullen. So that is in there, and that is something we're requesting, Your Honor, based on that agreement the parties reached in 2009. And as far as our number, so Mr. Mullen, before we came in here today, I don't think we differ as to what he has paid. He's referencing a check from $7,000 that he paid earlier in January of this year, but that was for medical expenses that covered 2016 expenses. So we did give him credit for actually a $200 overpayment on our spreadsheet, as well as $1,613.83 that he paid on June 17th, 2017. And I mean, so our numbers are accurate as far as, we have invoices to back this up. Mr. Mullen mentioned that he had a dispute with some of these items, but that's essentially what we're asking for. And then we do have new items to add. That's not on the worksheet, the Excel spreadsheet I filed with the court. That reflects the new amount I was referencing. Propose another number. He just generally talked about there's a dispute over whether the sensor that's necessary for Mrs. Mullins' diabetic supplies, and he mentioned a dispute about the Dignity health food at the hospital. He didn't even want her. So those are the things that was brought to my attention. Otherwise, I wasn't given a number by Mr. Mullins.
Mr. Mullen, I'm not asking you to give me numbers, but I mean, do you believe that that a number can be reached on or not?
I'm confident we can find that we can agree on a number. Its ability to pay at this point in time, but I will absolutely endeavor to do that. It's not my intention to come before you, sir.
Well, let me just say this. Let me just say this to both of you. Let me just check something real quick. All right. Now, here's why I really think you should settle this. I'll set a hearing date, but I think you should settle it. Ma'am, I'm not discounting your need for the money. However, it sounds like he's not able to pay. Now, if we have a hearing and the evidence shows that he's able to pay, that may work against him. But if the evidence shows he doesn't have the ability to pay and all he can do is get a judgment, that's something that your attorney and him could work out. If you can reach a number and agree on a judgment, then you're required to execute on it like you would any judgment. Now, as regards to attorney's fees, this was brought in family court, Ms. Baga. Now, my interpretation of the rules and the statute, the case law, the statute, is that if a petition to enforce is brought in family court, I am bound by 25-327. The fact that the parties agreed that the prevailing party gets attorney's fees is not of any relevance in the family court. I will not countenance that, because the case law says that those kind of provisions are contractual. They're not family court. So I have to find that Mr. Mullen acted unreasonably to order attorney's fees. That's all. I mean, and man, I'm not trying to. Your agreement says what it says, but unless this was brought in civil court, that prevailing party rule doesn't apply in family court. So if I find that Mr. Mullen acted unreasonably, and that would be mostly because I would find that he has the ability to pay and didn't pay, it's very likely I may not award attorney's fees. So it's possible that Mr. Mullen could be found in contempt if I find that he has the ability to pay or had the ability to pay. However, if I don't, and I find that it wasn't unreasonable, he just didn't have the money, you may not get any attorney's fees. So I will set this for a hearing, but I really think that if you can get a judgment as soon as possible, a judgment amount, and then go execute on it as best you can, that's not much more than I can do. Because if I don't find attorney's fees, all I can do, like I said, unless I find that he has the ability to pay, but if I find he doesn't, all I can do at a court hearing is enter a judgment. That's all I can do. So, how much time do you think this trial is going to last, Ms. Baga?
Your Honor, I would think that our side would 45 minutes or to an hour. I know the court's limited with time for these kinds of matters, but I would request 45 minutes or more if the court does have time for that.
For your side, you mean?
Yes, Your Honor.
Okay. What do we have that's 90 minutes?
An hour right now?
Yes. Yes.
November 14th at 10 a.m.
All right. I have November 14th at 10 a.m. for
10:15, sorry.
10:15 for 90 minutes.
Your Honor, I'm actually unavailable that day.
Okay. That's fine. You don't have to tell me why. I believe you.
Is there a shorter amount of time that's available prior to that? If we had to reduce our time to 30 minutes and instead have a full hour, I would just.
You get 45 minutes to present your side. Now she's asking if I can get a sooner court date. She's asking for 30 minutes and 30 minutes. Do you think you can present your side of the case in 30 minutes?
Probably, Your Honor.
Do you have anything sooner than November 14th for 30 minutes?
November 6th, 11 a.m.
I have November 6th at 11 a.m. So, Ms. Baga, you tell me if those 8 days are worth 15 minutes to you.
November 6th. Yes, Your Honor, I'm clear on that date.
What time?
November 6th at 11 a.m.
And Mr. Muller, are you available November 6th at 11 a.m.?
I'll make myself available, Your Honor. There's a trip from Denver, but I will do it.
All right, thank you. I'll set this then for an evidentiary hearing on the petition for contempt on November 6, 2011 at 11 a.m. Now, obviously that's over a month away. That may be one more reason to try to resolve this before then. And the only reason I suggest resolving it is obviously, Mr. Mullen, if I find that you do have the ability to pay or did have the ability to pay, I can find you in contempt. However, I can't put you in jail because under our laws, unless it's child support related, and that's not an issue here, the court has no power to put someone in jail for not paying a debt because that goes against the age-old rule that we don't have debtors' prisons in this country. Which means that the only remedy I can afford if I do find he's in contempt is attorney's fees. And again, that's obviously something you should think about. And Ms. Mullen, obviously, if I find that he's not acting unreasonably, then you may not get attorney's fees. And so it may be beneficial for you, ma'am, to try to resolve it as opposed to having your attorney prepare for a hearing, go to a hearing, do whatever post-hearing things are necessary, which are all attorney's fees. So I understand that you need the money, ma'am, and I'm not discounting that at all. I'm really not. I'm just telling you the facts of these kind of cases. So it is set for a hearing, November 6th at 11. If you can't resolve it, we'll have a hearing that day. But I do hope that you can resolve it to both parties' satisfaction, and that we don't have to have a hearing that may not come out any better than a settlement would. Ms. Blaga, anything else today?
No, nothing further. Your Honor.
Mr. Muller, any questions or anything from you?
Just a clarification,
Yes, sir.
please. So if we reach an agreement, then that will negate the hearing, correct?
If it's a full agreement, yes, sir.
All right. And
Now, she may still ask for attorney's fees, and that's something you got to deal with. And,
Right.
And if she persists in that, if that's her right, and you don't agree, then we'll have to have a hearing. But yeah, as long as there's a full agreement on everything, then yeah, this hearing will be vacated.
all right. And just one more question.
Yes, sir.
I'd like to request that if she sends something to me, don't ask for a signature. My job requires me to travel pretty much all the time. And the first time I found out about this was just a week or so ago. 2 weeks ago when I got papers served to me.
Right.
Because I think she may have tried to send something to me because I had some FedEx stickers on the door that they couldn't deliver, but they required a signature, required my signature, and so.
Well, I can tell you right now that and you might want to read the rules. There's a Rule 49 under the Rules of Family Law Procedure that talks about exchanging documents. And at this point, now that you're in court, you've been served officially, Ms. Blaga's only duty is to send you things by regular mail or by email.
Okay.
And she won't request any signatures.
Okay.
The only time she'll request a signature is if there's any kind of agreement to be signed. But no, the rules don't require her to do that, and I doubt she'll do that. She'll just mail them. And now, just so you know, once she does that, it's presumed that you've received them unless she gets a return mail.
Absolutely.
And so it's difficult. I've seen people say, I never got it, but the court's going to presume you got it if she sent it. So,
Yeah.
But that's, you won't have
I'm
to
not
sign.
suggesting she didn't send it.
Yeah, you won't have to sign anything, though.
Okay. That'd be great.
I think that's right, Ms. Blaga. Ms. Blaga, you have nothing that you'd be sending it to for signature.
No, Your Honor, we only served him, and that
Right.
was the only thing.
Right.
It may not have
Now-
been related to this thing.
In that regard, and I'll tell the court about today's hearing, and in there will be some instructions on what you have to do for the hearing. There are 3 basic things you have to do. you have to provide, both of you have to provide, it'll be in the order, but I just want to say it now so there's no confusion. You both have to provide to each other any information, any documents that you think are helpful to your case or harmful to the other side, or that are important to your case. And that's got to be done at least 30 days before the hearing, so that's coming up pretty soon. The next thing is if you have any witnesses you plan to call. I can't imagine you would, but if you do, you have to provide the names and contact information to each other by email, mail, however you want to do it, 30 days before the hearing. And the last thing is, if you have documents that you want me to look at during the hearing, they're called exhibits, you have to provide those to my clerk 7 days before trial. And when I say provide them, don't mail them 7 days before. Either mail them 2 weeks before so we get them in time, or you can come to the courthouse here. There's a phone across the hallway there. You can call my staff and say, I have the exhibits. My staff will come out and get them. My clerk needs 7 days to get them marked as exhibits. It doesn't take her that long to do it, but she has other cases, and so she gets a backlog. That's important because I can only look at documents that have been marked by the clerk as an exhibit. If they're not marked by the clerk, you can have them marked during trial, but that obviously takes time away from your time limits. So if you do that, everything's fine. You'll have your exhibits. You can just show me, and things will move smoothly. Let me be sure, Mr. Mullen, we have your address. So that. What is your address, sir?
5743 Hickory Circle, Frederick, Colorado 80505.
Hold on, is that what you have?
No.
All right, go ahead. Say it slower, please.
5743 Hickory Circle. I thought it was the same one that was on here. And it's Frederick, Colorado.
How do you spell that, sir?
Frederick.
Okay. And the zip?
Yeah, that's what. It's the same thing that's listed on this document, sir, that I received.
Well, that may be, however.
The address we have is Arapahoe Circle, so
Okay.
whatever circle we have.
Yeah, I'm sorry, that's an older address.
Yeah, you need. I'll just tell you both. Under our rules, if you move within 10 days, you have to file a certificate of change of address. It's a special form at the clerk's office. You can get it online. But if you don't, what's your zip code?
80504.
805.
It should be the same zip code.
All right. If you don't do that, no matter how many pleadings you file that has your address on it, the clerk will not pick it up. It's got to be done by that certificate of change of address. But now you don't have to do it, sir, because we've done it in court. But in the future, both of you, even though you're represented by counsel, ma'am, you've got the same obligation.
Yes.
Because at some point your counsel will withdraw, and then all we have is your address, so it's got to be updated. All right, Ms. Baga, anything else today?
Yes, Your Honor. One more thing. There is a email provision. It was one of the things I raised in my petition for contempt that requires a email response from Mr. Mullen in 24 hours upon receipt of an email from Ms. Mullen. That hasn't been being followed, and so I just want to ask the court. I mean, I'm not sure what the reason for that was, but it really is hampering Ms. Mullen's. So she can't get in contact with him, and sometimes he's just kind of disappeared for 30 days without responding. So.
Do you know what page of the decree it's on?
It's actually on the parties entered a stipulated order. I think it's called a consent decree regarding petition to enforce in 2013. And it's actually paragraph 2 in that document.
We're not having a hearing today, so I'm not asking you to tell me if you abided by it or not, but I'm telling both parties that they have to abide by the orders of the court. And this was signed by Judge Hicks and filed with the court on October 8th, 2014. So both parties have to abide by it. I believe that that is one of the grounds for the petition for contempt, so that's something that I'm sure will be discussed if you don't resolve this. So you both realize you have to follow whatever orders exist. You understand that, right? All right. Anything else, Ms. Baga?
No, thank you, Your Honor.
All right, Mr. Mullen, anything else today?
No, sir.
Let me just ask you, do you have access to legal advice or a lawyer or somebody just to talk to about what?
I have no extra money beyond the bills I pay, so that's why I don't have one.
All
I
right,
can see if I can find someone that can.
let me give me this flyer, please. I'll give you a flyer so that it has a couple agencies that do family law work that's at low cost or no cost, depending on your income. I do suggest that you try to speak to somebody,
Yes, sir.
perhaps one of these agencies. They can't represent you in court. They can't file pleadings for you, but they can make an appointment. You can make an appointment, and they can answer some questions you may have about this process and what you might be looking at, what she might be looking at, just so you understand what's going on.
Yes, sir.
Okay?
I appreciate your help.
All right. Then if you don't settle this, I'll see you in November. Thank you.
sir.
We're adjourned.